So we'll review the first 11 sections of the Bill of Rights, Kentucky's Bill of Rights, because not only do these expand our liberties and our rights, but it also doubles down on the rights and freedoms that we have. So the right from search and seizure isn't just from Kentucky's Constitution. I think the Fifth Amendment, maybe, Fourth Amendment. I'm not sure, but Section 10 of Kentucky's Constitution is the security from search and seizure, and you have to have a warrant. So you could say, well, according to Section 10 of Kentucky law, you don't have a right unless you got a warrant to enter our premises. So that's Section 10, unless they spell out exactly, you have nuclear warheads in your microwave, and that's, they have to say what the goods are and where it's at. And that's the only way they can have a warrant. So they have to say exactly what it is they're looking to retrieve and where they're going to be looking for it at. Okay. So the first section is that all men, by nature free and equal, have certain inherent and inalienable rights. So the first one is to defend the right, the self-defense of liberty and life, the right to worship Almighty God, the right to seek and pursue their safetyness and happiness, the right of freely communicating their thoughts and opinions, the right of acquiring and protecting property, the right of assembling together in a peaceful manner for the common good, applying to those interested with the power of government for the redress of grievances and other proper purposes by petition, address, or remonstrance. The right to bear arms in defense of themselves and of the state, subject to the power of the General Assembly to enact laws to prevent persons from carrying concealed weapons. Section 2, absolute and arbitrary power. Denied absolute and arbitrary power of the lives, liberty, and property of free men exists nowhere in the Republic, not even in the largest majority. Section 3, no exclusive grant except for public services, property not to be exempted from taxation. Grants are revocable. All men, when they form a social compact, are equal. No grant of exclusive, separate, public emoluments or privileges shall be made to any man or settlement except in consideration of public services. But no property shall be exempt from taxation except as provided in this Constitution, and every grant of a franchise, privilege, or exemption shall remain subject to revocation, alteration, or amendment. I'm not for sure exactly. I think that's anti-corporate language, and it's saying that nobody should, for public services, you can't take any public land unless there's public services. So you can't steal other people's land unless you're using it to provide water for other people, or electricity or internet. Section 4 is the right to violent revolution. All powers inherent in the people and all free governments are founded on their authority and instituted for their peace, safety, happiness, and protection of property. For the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in such manner as they may deem proper. Section 5, no preference shall ever be given by law to any religious sect, so right of religious freedom. Elections shall be free and equal. That's Section 6. Section 7, rights of a trial by jury. The ancient mode of trial by jury shall be held sacred, and the right thereof remain inviolate, subject to such modifications as may be authorized by this Constitution. So anybody with any type of accused crime has the right of trial by jury, since this ancient mode of trial by jury shall be held sacred in the Commonwealth of Kentucky. Section 8, freedom of the speech and of the press. So they'd already said that we have a right to express our opinions freely, but they're saying now freedom of the press. And printing presses shall be free to everybody, so everybody's allowed to have a blog in Kentucky to examine the proceedings of the General Assembly. So any governmental branch, you're allowed to, the Sunshine Law says that you're allowed to be there and you're allowed to record them, but anybody's allowed to examine the proceedings of any governmental body. No law shall ever be made to restrain the right thereof. Every person may freely and fully speak, write, and print on any subject, being responsible for the abuse of that liberty. So we're allowed to speak in any ways, but they do talk about the abuse of liberty, and that's when Section 9 comes up. Truth may be given in evidence, prosecution, for publishing matters, proper public information, jury to trial law and facts, and libel prosecutions. In prosecutions for the publication of papers investigating the official conduct of officers or men in a public capacity, or where the matter published is proper for public information, the truth thereof may be given in evidence. And in all indictments for libel, the jury shall have the right to determine the law and the facts in the direction of the court, as in other cases. So that's libel. They can try you for libel. The best defense against libel is the truth. So if you print the truth, well, that's the truth. That's what happens. And so yeah, and it also talks about the people in public capacity. So this kind of protects the politicians in a way, but it only protects the politicians from lies that people make up. So you're not allowed to make up lies about public politicians. And right. And so Section 10, security from search and seizure, conditions of issuance of warrant. The people shall be secure in their persons, houses, papers, and possessions from unreasonable search and seizure. No warrant shall issue to search any place or seize any person or thing without describing them as nearly as may be, nor without probable cause supported by oath or affirmation. Same thing I already mentioned. Rights of the accused in criminal prosecution, change of venue. So this is Section 11 of Kentucky's Constitution. In all criminal prosecutions, the accused has the right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. So if you're accused, you can force other people to be witnesses in your favor. In Kentucky, that's Section 11 of the Constitution. And also, think about this. The Section 26 says that all these first 25 sections are superior to all other laws, so everything else is subordinate to these laws. In order to guard against transgression of the high power which we have delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate, and all laws contrary thereto or contrary to this Constitution shall be void. So Section 26 says that the first 26 sections of Kentucky's Constitution are the main sections. All the rest of them are the division of powers and how government operates. All of them are subordinate to the individual rights and freedoms that every citizen in Kentucky has. So the rights of the accused in criminal prosecution, this is Section 11. So he cannot be compelled to give evidence against himself, which is the Fifth Amendment, nor can he be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. So actually by putting somebody in jail, that's depriving him of his liberty without the judgment of his peers or the law of the land. So that means someone has to issue this judgment and has to be put down. He shall have a speedy public trial by an impartial jury of the vicinage, but the General Assembly may provide by a general law for a change of venue in such prosecutions for both the defendant and the Commonwealth, the change to be made to the most convenient county in which a fair trial can be obtained. So you can have a change of venue if there's a conflict of interest, if there's morality, you're not allowed, nepotism and spoil system, and you're not supposed to be able to help your buddies out and shit, and go after your personal enemies. You're not allowed to use the county attorney spot or sheriff's position or the county judge's position as Nixon would, just to go after your enemies. So no person for an indictable offense shall be proceeded against criminally by information except in cases arising in land or naval forces or in the militia when actual service in time of war or public danger, or by leave of court for oppression or misdemeanor in office. So indictable offense not to be prosecuted by information. No person for an indictable offense shall be proceeded against criminally by information except in cases arises. In cases of information, I guess if somebody just is informed, and then so there should be a trial. Double jeopardy, property not to be taken for public use without compensation. Section 13, no person shall for the same offense be twice put in jeopardy of his life or limb, nor shall any man's property be taken or applied to public use without the consent of his representatives and without just compensation being previously made to him. So this goes to eminent domain, and this goes to double jeopardy. So you can't try somebody for the exact same trial or for the exact same crime twice. You can't do that shit. And you can also you can't take someone's land unless it's for public services, unless you give them just compensation. So you have to pay them for the land that you take. Section 14, right of a judicial remedy for injury, the right of a speedy trial. Section 14, all courts shall be open and every person for an injury done him and his lands, goods, person, or reputation shall have remedy by due course of law and right and justice administered without sale, denial, or delay. Section 15, laws to be suspended only by General Assembly. No power to suspend laws shall be exercised unless by the General Assembly or its authority. Section 16, right, so only General Assembly can undo the laws, and they've undone so many laws. It's really the legal system in Kentucky is a mess. Section 16, right to bail. Habeas corpus. All prisoners shall be bailable by sufficient securities unless for capital offenses when the proof is evident or the presumption is great, and the privilege of the writ of habeas corpus shall not be suspended unless when in case of rebellion or invasion the public safety may require it. So they're saying unless they're completely guilty, you can't hold somebody in jail unless it's for a murder, a capital offense, and you can't hold them until trial. You have to, for sufficient securities, for an amount of money, you can get bailed out, right? And then you have to show up for court, and then you get that money back. And you should get that money back. So that's what the writ of habeas corpus is to protect your person. So that means they can't hold your person behind bars in prison. They have to have a right to bail. You have to be able to, put up some money in order to get out. And then also the unless in case of rebellion or invasion. So in cases of war, and since we are in wartime, I'm not sure how that actually plays into the effect of Kentucky law. Section 17, excessive bail or fine or cruel punishment is prohibited. Excessive bail shall not be required, nor excessive fines imposed, nor cruel punishment inflicted. That's Section 17. If you put a poor person behind bars and you give them a $2,500 bond, you know that you're just going to fucking hold them motherfuckers until, for however long. And so that's excessive bail. And it's not required. You can't have excessive bail or excessive fines nor cruel punishment, especially when you are innocent until proven guilty. So by putting a high bail on somebody, that is punishing them before a verdict has been rendered against them. Section 18, imprisonment for debt is restricted, so you can't put anybody into prison for a debt. The person of a debtor, where there is not strong presumption of fraud, shall not be continued in prison after delivering up his estate for the benefit of his creditors in such manner as shall be prescribed by law. So once a person declares bankruptcy, they put themselves out in front of the open, and then people can take whatever it is that they want to take from them. If there is anybody that objects to it, so you have to let the person live. But if they have anything extra, then that goes to their creditors, and you cannot put anybody for that is in debt in jail. So that's Kentucky. That's Section 18 of Kentucky's Constitution says you do not have to go to jail if you have a high debt to somebody, to the bank, to the electric company, to your landlord, etc. Section 19, ex post facto law or law impairing contract forbidden. Rules of construction for mineral deeds relating to coal extraction. So this all has to do with coal extraction, Section 19. Number 1, no ex post facto law nor any law impairing the obligation of contracts shall be enacted. So contracts are fucking central to business law. The contract is the central fucking instrument for anything. In any instrument heretofore and hereafter executed purporting to sever the surface and mineral estates, or to grant a mineral estate, or to grant a right to extract minerals, which fails to state or describe and express in specific terms the method of coal extraction to be employed, or where said instrument contains language subordinating the surface estate to the mineral estate, it shall be held, in the absence of clear and convincing evidence to the contrary, that the intention of the parties to the instrument was that the coal be extracted only by the method or methods of commercial coal extraction commonly known to be in use in Kentucky in the area affected at the time the instrument was executed, and that the mineral estate be dominant to the surface estate for the purposes of coal extraction by only the method or methods of commercial coal extraction commonly known to be in use in Kentucky in the area affected at the time the instrument was executed. So if you understood any of that dense language, just essentially where, do you own the surface rights, do you own the coal rights, and where does that line get severed? And they said that this text was actually ratified November 8th, 1988. So this is very new section that was put in, and it's all about the surface rights to the mineral rights. So the mineral rights are under the surface rights, right? I can own the land, and then I can own the rights underneath the land and sell those rights out, and then they can extract everything underneath me. Then my land collapses down in there, and I get the surface dirt, even though it's like all over the place. Then, and it's actually kind of fucked up that coal companies can buy the land underneath you and not the actual land itself. It makes it cheaper for them, right? And they don't have to dig anybody up. And if they do it properly, then maybe it wouldn't have any bad effects to it. Section 20, a tender operation of restricted No person shall be attainted of treason or felony by the General Assembly, and no attainder shall work corruption of blood, nor accept during the life of the offender forfeiture of estate to the Commonwealth. I have no idea what that means. No person shall be attainted of treason or felony by the General Assembly, and no attainder shall work corruption of blood, nor accept during the life of the offender forfeiture of the estate to the Commonwealth. Section 20.